And she was like, oh no, what are we going to do? And then the next thing she knew, like an hour later, I had the whole machine pulled out and the back removed and was pulling out the clothespin and putting it back together. You want to have a little more certainty on that, because to redo that later is very expensive and very disruptive to the business. You know, you have to be strategic in where you're going to enforce and not, because it's game of whack-a-mole. And so what could be happening as these models are getting trained is that bias of a particular brand is being built and generated, but you might not know it yet, right? And by the time you know it, when either the next version or whatever comes out of it, it may be too late. Some of it may be nefarious. It could be someone is pumping the model with negative information about a competitor and you don't know it until later. What you really should have been focused on the output is diluting the strength of your work in the field.
This is the Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, the podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadio. My guest today is a trusted counselor and formidable advocate who protects the most valuable assets a business has, its ideas and its reputation. She advises a diverse group of clients, from startups to global corporations, across industries as varied as retail and manufacturing to biotech and pharmaceuticals, and has received numerous accolades for her work. It's my pleasure to welcome Tiffany Gehrke to the podcast. Welcome, Tiffany, and thank you for being here.
Thank you for having me.
Tiffany, as you know, I like to start by asking each of my guests either a fun fact about themselves or a cringe joke. Which will it be for you and what is it?
I have a cringe joke, and in the spirit of Halloween, I thought I would ask, what is a witch's favorite subject?
A witch's favorite subject? Something to do with brewing? I don't know. It's a good one.
Spelling.
That's a good one. We haven't had too many cringe jokes recently, so I appreciate the cringe joke and I appreciate the timeliness of it. So thank you for that. Fantastic. So with that, let's move on to starting to ask some what I think are interesting questions about your profile and your background. I think of every attorney who makes the time to be on this podcast as a superhero, and every superhero has an origin story. What's yours?
So mine is that from a very young age, I like to figure things out, right? Like I like to build things, I like to fix things, I like to learn how things work. And my mom tells a funny story of when I was in somewhere around fifth grade, a clothespin dropped down the lint chute of our dryer at home. And she was like, oh no, what are we going to do? And then the next thing she knew, like an hour later, I had the whole machine pulled out and the back removed and was pulling out the clothespin and putting it back together. And I surprised myself and I surprised her that day, but we fixed it and it was fun. And I just, really liked that kind of stuff. And a few years after that, I had a junior high teacher who taught everyone in the class had to learn how to program, how to write code. And I thought it was so neat that we could make computers do things that, back at the time, it was like an Apple IIgs computer, that if you just booted it up without a disk in it, you could write in that code language. And I thought that was fascinating. So that kind of got me interested in like science and technology as things were. So when I decided to go to college, I thought engineering was a natural fit for that, because I thought it would be a great way to kind of learn how things work and then learn how to problem solve from that. So that's what originally, sort of took me into the workforce.
That's amazing. I can really identify with that. I'm myself trained as an engineer, so I know exactly what that is. I have a huge respect for that. So thank you for sharing that. So can you maybe walk us through, all right, so you went into college, you studied computer science or computer engineering. What was your post-college journey like? When did the pivot to law happen? What were some of the driving factors for that?
Yes. So I worked at a couple of different programming jobs right after college. The first one was at like a food service company. So if you think of like who makes airplane meals, school lunches, nursing home meals, like all of that kind of food where it has to be pre-made for many people and meet certain nutritional requirements. I worked on a couple of software applications that dealt with one, the inventory side of things, of production management, where are things stored in warehouses and how do you get the ingredients you need to the lines that you need at the appropriate time, and then where things are tracked and stored afterwards. And then the other side of an application that I worked on had to do with using the nutritional information and cost parameters on meals so dietitians could structure what the meals were going to be. And in that role, I loved figuring out how things worked. I loved hearing about, how people were using the different rows and different categories in the warehouse to make things efficient too for the workers out there, that they're not running back and forth to different rows at different times. And I thought that was really cool, but I couldn't see myself doing that every day forever, right? And I saw an opportunity to work for a company that did disease management, which was at the time not its own like healthcare company, but it was more of an add-on to healthcare companies where they looked at data and they saw, okay, this family had an emergency room visit for a child that had asthma symptoms. You know what we should do? We should help educate that family on what asthma triggers are and what information they might need to be able to prevent that kind of emergency room visit in the future. And the company's, drive was twofold. It was one that saves money. So employers want that because it helps to keep costs down. And then on the other side, it helps people better manage their sickness and their diseases so they are healthier and they aren't, experiencing last minute urgent needs. And at that company, we did a lot with data, a whole lot, as you can imagine, pulling from different sources, pulling different information, and trying to streamline it into a single platform that could be workable and usable for these nurses to look at this information, pull things up, and to talk directly to families. And I had some incredible bosses at that job that I really, really liked and valued. But after a little bit of time, it started to happen again where I was like, I don't know that I can do this forever. So what am I going to do? And I knew someone that was a trademark attorney. And they were like, you should consider IP, you should consider, patent law and trademark law and all of it. And I didn't really know what it was. I hadn't really heard of it. So I started looking into it and I thought, oh, this could be a way that I could continue sort of the passion for innovation and the passion for learning how things work and how they go and have a different layer on top of it. So I decided to go to law school and I went at night while I continued to work during the day for the first few years and really just thought it was kind of a perfect match. And that's what got me into intellectual property and where I've been ever since.
That's amazing. Understanding that not only what your strengths are, but what your likes and dislikes are, and sort of navigating your way through all of that, and then going to law school while you still had that job. I think that's a tremendous level of commitment, and kudos to you for that. So what were your early years in trademark law like? Have you always been focused on what you focus on today, which is digital brands, and we'll get into that, or did you start off maybe by casting a wider net and then sort of narrow in on what you do today?
Yeah, I did do more. When I first started, I did a lot of litigation on the patent side as well. It was very, very busy with non-practicing entities and patent trolls at the time, particularly in the e-commerce space. So there were a lot of clients that were targeted that had websites or storefronts, and a very popular thing to have lawsuits over at the time was how you could sort and group like online shopping. They called it taxonomy of, what category something is, what color it is, what product it's compatible with, all of that. So there was a lot of litigation when I first joined Marshall Gerstein in that space. So I did a lot of that work while also doing a lot of trademark work at the same time and helping counsel where and what do you want to file your applications for? How do you clear a mark? How do you understand what your risk may or may not be and do all that? So over time, it is shifted more to the trademark side, although I still do some patent litigation as well, but I'm primarily focused on the sort of the brand counseling and strategies that go with that.
Sounds good. On the patent side, I remember a few years ago, maybe even a decade ago, there was this small town in Texas which had like a bunch of empty storefronts. And were you involved in that, or was
Yes,
that a part of what?
yes, that was one of the places that I traveled when when I was first starting out.
That's funny. And so, all right, so you move from patents to trademarks. Now, what is it that you do typically? Where did you get your start on the trademark side, and how has that evolved in the years that you've been working on?
Yeah, so the very first job that I got out of law school was actually doing trademark work. So that's what sort of brought me into it, and then I never let go. So while I also did, patent litigation at the time, we had enough need on both sides of the house, and I was able to sort of keep both going while I was learning and growing as a young practitioner.
That makes sense. For those listeners who may not be fully aware of some of the nuances between the two, I mean, I think we all know what a patent is versus a trademark, but what are some key, I would say, unexpected differences in terms of how you approach your work in both of those categories?
Yeah. So on the trademark side, you're thinking sort of twofold. On one side, you're thinking, where can I carve out my space to build my reputation to make sure that when I do all this great work or I create these great products that consumers know they're coming from me, right? So you're sort of saying, where can I grow? Well, on the flip side, you're also thinking, okay, if I want to be in a space, is there enough room for me? Where do I want to mitigate risks so that I don't step on somebody else's rights? Or even if I'm not going to step on their rights, is there enough room for me to grow and be there long term if that's something that we want to do with whatever the brand is? So that's sort of the trademark side of things. On the patent side of things, it's more looking at where is the market and where do you want to invest your rights. I don't do patent prosecution to accrue the rights in the patent. My colleagues handle that here. So on the patent side of things, when I'm helping, it's more of either a patent has been asserted against one of our clients, and we have to look at the elements of the patent and do we actually do what the patent says, or is there some reason that we don't infringe? Or if we're the one that owns the patent, we're considering, asserting it against another party. You're looking at making sure that based on the information available, they do actually practice each of the items that they're required to so that you have a viable cause of action on that side.
Sense. Um, your work spans a broad range of industries, as we mentioned in the intro, everything from biotech to pharmaceuticals to retail to manufacturing. How does your approach towards your practice differ by industry, if at all it does?
It definitely does. And even within industries, based on the risk tolerance of a particular client. So in certain spaces where it might be they're going for a marketing campaign that's going to be short and sweet, they might have a risk, a different risk tolerance of something that's going to only be on social media that can be changed quickly versus, hey, we're launching a new product. We're going to have to manufacture this 10 months in advance. We're going to have to label it and product it, and we're going to significantly invest in it. You want to have a little more certainty on that because to redo that later is very expensive and very disruptive to the business. So you have to sort of think about what's the point of whatever the client is going to do and then consider the trademark strategy behind that. And then on top of that, you layer on what is that client's risk tolerance because everybody's different.
Makes sense. So I guess while on the subject of risk and even abstraction, I would imagine that the fact that there are so many digital innovations out there and trademarks related to the digital world and digital brands out there, I think that adds probably another layer of complexity to your work and to what your clients have to think about. How do you advise a client on protecting a trademark for a digital product? Let's say a virtual handbag or something that exists in the metaverse that doesn't have a physical presence, that doesn't physically exist. What are the rules of the road in this regard?
Yeah. So the North Star is basically where are their consumers? Where are the consumers going to be encountering their brand? Where are they going to be purchasing? Where are they likely to be misled by a bad actor? And crafting a strategy around that. So online, there's a couple of different ways that you do it. One thing is domains, right? So we are always cognizant of what domains are being registered that might have your client's brand. It might be one of their house brands. It might be a big popular brand. Where is it? And we have different enforcement mechanisms for domains than you may for a third party retailer or reseller where you can, purchase products. So on the domain side, where, you have to be strategic in where you're going to enforce and not because it's a game of whack and mole. right? There's almost infinite domains out there with different, top level, GTLDs like the .com or the .net of the world. So you have to be thoughtful and strategic about what it is. And then you can use procedures like, I don't know if you're familiar with the UDRP procedure. It's a sort of an alphabet soup of different acronyms, but it's a mechanism where you can get a domain from a bad actor if they meet certain requirements. You can use an arbitrator to go and get the domain and get it transferred to your account instead of them using it if you meet these, requirements and you are successful in your complaint. But it's more of it's a faster, cheaper way to do that than to say file a federal litigation complaint alleging infringement based on that domain.
Sense. And I would imagine adding to another layer of complexity when you think about these bad actors is that there's bad actors everywhere, but presumably there's a lot of them that affect your US based clients that are not necessarily based in the US themselves. So how do you work in this sort of environment where the bad actors might be anywhere in the world, and how do you go about with enforcement in that?
Yes. So some of it, that UDRP procedure, there are equivalent versions of it for various different country code extensions. So, if it's like .cn in China or .uk in the UK, they have versions of it that are very similar that you can do that type of procedure. The other thing that we rely on is our network of foreign counsel around the world. So, myself and others that I work with are in a lot of organizations where you meet and interact with local counsel in a different country or a different jurisdiction that does trademark law there, and through those relationships you're able to get some comfort of who you're working with, and they're the expert in their own jurisdiction, and sometimes we partner up and say, hey, this is happening, what do you recommend remedies are available, or what causes of action are available under your jurisdiction's rules, and what are the costs and what are the risks with that, and then we can coordinate that information to counsel our clients.
That's fascinating. So you almost have to team up sometimes across borders with your counterparts in other countries where those bad actors might be operating, and sort of that's fascinating. Yeah. How frequently, I know each case is different, but how frequently does that happen, or what percentage of your cases involves sort of overseas coordination of the type you just mentioned?
I would say the majority is either US based or can use US based procedures, or procedures that are available to us in the US, I should say. They're not necessarily based here, because there's a lot of governance that has over the internet, or is becoming over the internet, or changing over the internet, that is like multi-stakeholder. So no one government is in charge, but it's sort of an agreed set of terms that people are going to abide by. And the most commonly known one is that UDRP procedure that I've mentioned. And registrars opt in that they will participate in this, and that they will abide by the rules of it. And some of this over the last few years has been changing a bit, the governance of it. And we'll see where it continues to evolve over time. But for now, that is a pretty powerful tool to disrupt a bad actor who's running a website that is problematic. If they're not doing it through a website, right? If they're doing it through third-party marketplaces, then almost all of the big ones have their own takedown procedures that, if you're in the US and someone is trying to use counterfeit products, right, to sell them to US consumers, you have a couple of different ways to stop it. You can use customs, you can use the ITC, the International Trade Commission, you can use things like, the Amazon brand registry to get the listings taken down. There's an equivalence on many other sites as well.
Since you've mentioned UDRP a couple of times, can you maybe
Yeah.
give like a couple of sentences on what that is, how that works?
Yes. So basically, if someone registers and uses a domain that either contains your trademark or is confusingly similar to it, and they don't have legitimate rights in it. So if you hit those three things, so bad registration and use, it's confusingly similar to your trademark, and they have no legitimate rights in it, then you can basically, you write kind of like a complaint. I like to think of it almost like a summary judgment motion, because you put it all right there in the complaint of why you've met all of these elements, and then they get the opportunity to respond. And if they do, then you may be able to get a little bit of a reply. It depends on which forum you file in. and then it goes to an arbitrator. It can go to 1 or 3. You get to pick if you want 1 or 3. They have a list of pre-approved arbitrators that make the review it and then make the decision on it. If you either way, if it finds against you, we'll say there is an opportunity to appeal, but otherwise your next step would be to go to federal litigation if you needed to. But it's a relatively fast procedure from the day you file to the day you get the decision. It's less than 2 months, so it can be fast too.
Yeah, that's remarkable. 2 months. I think that should provide some solace to your clients in terms of at least moving quickly, especially if they have some of those major investments that you mentioned earlier in the conversation about getting ready to go with something and having to deal with this along the way. So that's great. Switching gears a little bit to technology and innovation and AI, and how there's so many angles to this, but maybe we'll start with one, which is on your client side. I presume that there's plenty of companies out there who are increasingly using generative AI to create content, to build their brands, and so on and so forth. And that comes with its own set of presumably intellectual property issues on the AI model side. So what guidance are you giving to your clients who are presumably using generative AI?
Yeah, the number one thing we always say is be aware of the rules. Whatever tool you're using, read their terms and conditions. See what are you allowed to do, what are you not allowed to do, and make sure that you have an understanding of that type of compliance. And then, to the extent that you need to get permission for something, get permission. Right? To the extent you're not sure, well, then consider what is the business risk if you go forward with something that you're not sure about. What could the potential consequences or damages be? Or not, is it worth it in the context of whatever they're trying to do? But the main thing we say is be educated about it. And then we often suggest too that, the folks in marketing or the people that are going to be creating these tools, to make sure that they're also sophisticated users of it. So they know what they're doing, play around with it, get familiar with it, understand the language. A few years ago, when the metaverse was going to be a big deal, we were like, have someone that knows it, that actually goes in there, sets up shop, and plays around and understands how people interact within it, because it's a lot easier to understand the rules if you're in it versus if you're trying to just look from the outside or avoid it completely. You might miss opportunities. So you want to use it in an educated, smart way.
Makes sense. Switching from the use of generative AI by the companies and the brands themselves to the use of generative AI by others who want to maybe potentially imitate those companies and those brands. What do you see in terms of the landscape of of things like deep fakes and infringement and things like that? Where do things stand right now? Is generative AI acting as sort of an accelerant, and what do you see there?
Yeah, so this is where I see a little bit of a difference from trademarks to copyrights. We haven't talked much about copyrights yet, but first on the trademark side, one of the things that concerns me is that as these models are being built and training, bias is naturally built into that. And so what could be happening as these models are getting trained is that bias of a particular brand is being built and generated, but you might not know it yet. Right. And by the time you know it, when when either the next version or whatever comes out of it, it may be too late. And right now, I'm not aware of any mechanisms to sort of correct that if something comes out either false or disparaging or in a light that you don't want or is unfair or inappropriate. It can be damaging to your brand. And I wonder if, down the road there's going to be some sort of agreement or some sort of terms that provide a mechanism for brand owners to object, to request something be taken down. We have these procedures in all these other different ways, like the UDRP I mentioned. We've got takedowns, we've got all these other things that apply to different technologies that I would have to imagine something like that will evolve here, but I'm not aware of it being there yet.
That's interesting. I remember maybe a few months ago, earlier in the year, there was this little bit of a controversy around the Studio Ghibli and how some of the OpenAI drawings were sort of looking like they were inspired by it. Would that be an example of a copyright, if that's something that you're aware of with the Japanese studio, and how they were sort of, there was a time when all of these individuals would just sort of post videos of themselves or images that looked like they were made by this one Japanese studio?
So I think that would be more on the copyright side than the trademark side. So, but yes. And on the copyright side, sometimes there's easier breadcrumbs, I call it, to tell where something came from. There's a couple of cases pending right now, one of which has to do with images that have like a stamp on it. I think it's the Getty Images case. They have the Getty mark on it. So when a picture came out on the outside having that mark, you knew, oh, that's where they got it. But for words, copyright protected text, it's a lot harder to tell because words are common language. And so you might not know what the input was or how they got the input by looking at the output. So on the copyright side, that's kind of what I'm thinking. Back to the trademark side, though, I'm thinking of it more as, what's the best brand of cars? What's the worst brand of cars? Someone types that in, there's going to be something that comes out. And what is it and what is it based on? Is it based on a consumer survey that they surveyed the top blah, blah, blah people and they have it? Or is it more likely they've picked up comments that people have made, maybe on chat messages, maybe on boards, maybe on complaints? Maybe it's on a specific dealership. I don't know. There's so much data there that could influence the way like an opinion question kind of comes out. And some of that may be fair. Some of that may be okay, but some of it may be nefarious. It could be someone is pumping the model with negative information about a competitor and you don't know it until later. You know what I mean?
Absolutely. And as you were saying that, Tiffany, I was reflecting on sort of just from my perspective as knowing a little bit about how the AI models work is there's two levels of abstraction almost, which not even the model creators themselves can think about, right? What data was used in the training of the model and how that was sort of embedded into what the model quote unquote knows. And that's number one. And so nobody really exactly knows that. And then number two is if you and I both independently in our own separate ChatGPT windows ask the same question, we might get different answers and nobody can tell what the sources of those answers were or are and why it chose to give you one answer versus me another answer. So I would imagine that those are additional complications.
Yeah. Yeah, it is. It's interesting. And I'm sure, over time there will become like a process because people will object.
Right.
So it's a matter of how and what and what would be the reasonable way that it's governed. I'm not sure.
Yeah. On the copyright thing, you mentioned about words being common language. Now, there was a recent ruling, probably maybe a couple of months ago now, about Anthropic and them having to pay this massive settlement in aggregate. So what are your thoughts on that to the authors that they had to pay whatever amount they had to pay?
Yeah, so those were the sort of the two companion cases that came out at the same time, the Meta case and the Anthropic case. And as you've probably been following too, the Anthropic has now settled and the judge has approved a settlement, at least, for this stage of it. And the thing that I thought was interesting in both of those cases is that the judges sort of previewed, hey, we think you made the wrong argument here. And in each case, the issues, as I understand them, were really that they were focused on the input into the models, whether something was fairly or unfairly taken into the input to do the initial training, that first level that you were mentioning. And the Anthropic case, they said, okay, there was some stuff that was pirated and there was some stuff that they had purchased, cut up, scanned, and used only internally. And both judges in their various facts said, those were transformative uses. To train the model is transformative, which is one of the elements of fair use. They're allowed to do that. And on the outside, the argument, what they outputted wasn't that it was, oh, they identically copied a part of our thing and that's what was outputted. The judges said what you really should have been focused on the output is diluting the strength of your work in the field. You could create competitive novels, right? Or competitive whatever space, fiction I don't know what all the books were on, but like, the teen fiction vampire series or whatever it might be, which would then dilute the market for your work. And so both judges sort of previewed that they didn't think that issue was pushed hard enough in these cases, and that it was too much focused on lost licensing revenue from the authors initially to train the LLMs. And so what I'm curious to see is later cases, right? And what happens now is, are people going to focus on actually, you have really created a situation here where it's harming the potential marketplace for my copyright protected work because you took my work, trained your model on it, and then created outputs that aren't identical, but would dilute my space.
That's fascinating. It's so nuanced. So it's almost like the opportunity cost of maybe lower revenues than you would have had you not had these other competing, more easily produced
Yeah.
works.
Yes.
Fascinating.
Yes. Yeah.
Wow. So yeah, no, this has been a fascinating conversation, Tiffany. Just a few questions to sort of wrap it up. So you've had a wonderful journey, starting from the clothespin all the way to computer science and engineering, and then your first few jobs before you wound up in trademark and patent and IP litigation overall. If you wanted to give advice to somebody standing at that juncture today, maybe they're even in undergrad, just straight out of college or in college, and thinking about, hey, I like this, but I like this other field too. Should I think about law, especially given the complex confluence of technology and society and everything that we're living in today? What advice would you give them?
So the first thing I would say is do pursue law. I think it has been the absolute right profession for me. Maybe it's not for everyone, but I think that I recommend it. I think it's great. I think I've met so many nice people, so many smart people, so many intelligent people. It's been a really overall very positive experience. And then I would sort of tell them two other things. The first is like say yes to things, right? So when you're starting out, if say they are a lawyer and someone says, "Hey, do you want to go to this event with me?" Say yes. Go. Go do the thing. Do you want to join this organization? Yes, I do. Do you want to, we need someone to help put together this event for XYZ. I can help with that, right? Like say yes and do these things because they build shared experiences. You're usually working with someone else. And I always say, like, shared experiences build bonds, right? Like, when you do things together, you get to know each other. And those people that you get to know each other can, yeah, maybe it can be business development down the road, but more importantly, it can become a colleague, it can become a mentor, it can be a sounding board for you. It can help you feel like you have a community in this huge profession that we have with many people. It can give you a community of support and networks and resources and people you can refer issues to in the future. And it just creates a community. So that's number one, is say yes. And number two, I would suggest is to anyone starting off, whether it's in engineering or in law, but I'm sort of looking at it a little bit more in a law hat right now, is like take the time to learn what you need to learn, right? And to figure it out and to understand why something is the way it is. I think as technology keeps evolving, there's going to be ways that technology can make you more efficient. Fantastic. Embrace it. Do that. But don't lose sight of the fact that when you're having a conversation with someone, you want to know if you can answer a question versus being like, hang on, let me go look that up, right? Because anyone can look it up. You want to be able to understand the nuances of things. And then when you are relying on technology, you want to be able to see what it spits out and know, is that reasonable? Is that right? You want to have some gut instinct to that. So I think it's, don't shortcut yourself in the learning process. And some of that is slow and some of that involves reading a lot of things, right? It's not always the most efficient process as you're starting, but I think it's such an important foundation.
That's fantastic. On the question of learning, so if somebody wanted to learn more about the work that you do, resources around patents and trademarks and copyrights, all the things that we discussed, what would be a good resource specifically on the work that you do and just generally in the field?
Yeah. So if they're a lawyer, I would say subscribe to those daily email blasts that talk about cases. If it's IP law, do the IP 360, do Docket Navigator, do the TTAB blog, do Patently O, do the ones that are relevant to your field. And even if you're not reading them, scouring them every day, by looking through the headlines, you're learning, you're catching things, and you may even flag something that later hey, you know what? Didn't I see something on that? I can go look that up. Here's the case. And really use the value of these writers that are experts in what they're writing about. And they've so succinctly told you, hey, here's what this case is about. Here's the takeaway, and absorb that. So I would say the daily email blasts are very valuable.
That's amazing. Very simple and practical way to just stay on top of so many different things. That's cool.
Yeah.
Final question for you, Tiffany. Is there a question that I should have asked you, but I didn't?
Think so. I feel like you covered a lot.
I appreciate that. Well, Tiffany, thank you so much. This has been a wonderful conversation. I've learned certainly a lot. I appreciate your taking the time to share all these insights with us. And thank you so much.
Thank you.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.